We have noted that the Declaration of Independence is a statement of moral principles rather than a legal document. But even its famous assertion that all men are created equal omitted at least half the population. The U.S. Constitution was silent on the question of equal rights for women. That decision was left up to the states. States could choose to grant women equal rights, if they wanted to. None did, at least for a very long time. In fact, the opposite was true. States granted women few legal rights, instead placing many legal restrictions upon them. And they did so with the Supreme Court's blessing. In 1869, a woman named Myra Bradwell passed the bar exam and applied to be an attorney in the state of Illinois. Despite the fact that she was fully qualified under state law, the Illinois Supreme Court denied her application. She appealed this decision to the United States Supreme Court. In a unanimous ruling, they upheld the decision to deny her application. Justice Joseph Bradley authored a concurring opinion in which he wrote, "Man is, or should be, woman's protector and defender. The natural and proper timidity and delicacy which belongs to the female sex evidently unfits it for many of the occupations of civil life. The constitution of the family organization, which is founded in the divine ordinance as well as in the nature of things, indicates the domestic sphere as that which properly belongs to the domain and functions of womanhood. The harmony of the family institution is repugnant to the idea of a woman adopting a distinct and independent career from that of her husband." In other words, according to the Supreme Court, a woman's place was in the kitchen and bedroom, and they should never be allowed to pursue independent careers. In the following decades, women's rights advocates waged a fierce battle that ultimately succeeded in guaranteeing women the right to vote with the ratification of the 19th Amendment in 1920. Nevertheless, legal restrictions and distinctions based on gender continued. The fight to end public racial segregation and discrimination in this country was led by the NAACP and its brilliant attorney, Thurgood Marshall. The fight to end public gender discrimination was led by another brilliant attorney. Her name was Ruth Bader Ginsburg. Ruth Bader Ginsburg and Thurgood Marshall were similar in many ways. They were both outsiders who faced daunting challenges breaking into a legal profession dominated by white men. They both graduated from top law schools, and they both went to work for civil liberties and civil rights organizations. Thurgood Marshall worked for the NAACP's Legal Defense Fund. Ruth Bader Ginsburg worked with the American Civil Liberties Union, helping to establish their Women's Rights Project. And like Marshall, Ginsburg had a strategy. She realized that the Supreme Court had 9 men and 0 women. She realized that the justices might not be particularly sympathetic to claims of discrimination against women. And so she had a brilliant idea. She brought them cases involving discrimination against men. For example, she represented the male litigant in the case of Craig v. Boren. This case involved an Oklahoma law that allowed the sale of low-alcohol beer to women when they were 18 years old, but only allowed men to purchase beer when they turned 21. Wannabe party animal Curtis Craig filed an equal protection lawsuit. Oklahoma justified its law by pointing out that young men were far more likely to be arrested for various offenses related to intoxication, including driving while under the influence, than young women were. For example, studies showed that 2% of men between the ages of 18 and 21 were arrested for drunk driving, while only 0.2% of women of that age were. In a 7-2 decision, the Supreme Court struck down the law as unconstitutional. While it acknowledged that there was statistical evidence to demonstrate that men were more likely to be involved in alcohol-related offenses than women, it concluded that, while such a disparity is not trivial in a statistical sense, it hardly can form the basis for employment of a gender line as a classifying device. However, the court was split on an important question. It had previously declared that racial discrimination was a suspect class, and could only be permitted if the government had a compelling interest and a remedy that was narrowly tailored to meet that interest. The question in Craig v. Boren was whether gender discrimination was also a suspect class. 4 justices agreed that it was. But unfortunately for Ruth Bader Ginsburg and advocates of equal rights for women, they were not joined by the 5th justice that would have made gender discrimination a suspect class. Instead, the court invented a new, 3rd category. It declared that gender discrimination constituted a semi-suspect class, and cases involving gender discrimination would be analyzed using a new test. Rather than being analyzed using the strict scrutiny test, gender discrimination cases would be analyzed using the intermediate scrutiny test. What's the difference? In the strict scrutiny test, the government must demonstrate a compelling interest for its law or policy. In the intermediate scrutiny test, the government must demonstrate an important interest, rather than a compelling one. Secondly, in the strict scrutiny test, the government must demonstrate that its law or policy is narrowly tailored to achieve the interest. In the intermediate scrutiny test, the government must merely demonstrate that its law or policy is substantially related to that interest. So the intermediate scrutiny test is less demanding than the strict scrutiny test. Laws that discriminate on the basis of gender are slightly more likely to be upheld than laws that discriminate on the basis of race. But, in practice, public gender discrimination is unconstitutional in most circumstances. Two cases provide a study in contrast regarding the court's approach. In 1980, President Jimmy Carter issued an order requiring all men to register for the draft when they reached their 18th birthday. A lawsuit claiming that this violated the Equal Protection Clause was filed. In the 1981 case of Rosker v. Goldberg, the Supreme Court decided that it did not. Since only men were eligible for the draft, it was constitutional to require that only men register. But the court didn't address the issue of whether the male-only draft itself was unconstitutional. In a more recent case, a woman filed a lawsuit to be admitted to the Virginia Military Institute. The Virginia Military Institute is not part of the military, but it trains its students according to a strict military regimen that includes vigorous exercise and strict discipline. It did not admit women for its entire history. But in United States v. Virginia, the Supreme Court decided that, because it was a state-run institution, it must admit qualified women. In summary, the Equal Protection Clause provides significant protection against gender discrimination. It provides almost as much protection against gender discrimination as against racial discrimination, but not quite as much. Laws or policies that discriminate on the basis of race must demonstrate a compelling interest and be narrowly tailored. Laws that discriminate on the basis of gender must demonstrate an important interest, and they must be substantially related to that interest.